Once a lawsuit, a complaint is filed, that really starts the process of litigation. And one of the first things that's going to happen once the complaint has been filed is there's going to be an exchange of documents between you, the plaintiff, and the defendants. And there are going to be a series of questions, and it's called discovery. It's called written discovery. They're going to send us questions, and we're going to send them questions to try to get more facts about what happened in your case. And that begins the process. Once the written discovery part of the case is, I don't want to say finished, but once there's been a significant amount of written discovery completed, then there are going to be depositions. And depositions, that's oral testimony that a plaintiff and a defendant will give. They're going to sit down and they're going to put their hand up and they're going to swear to tell the truth, nothing but the truth, and they're going to answer a bunch of questions about the case. And depositions are really important because they have an impact on a person's credibility. It becomes very, very clear when you're sitting down whether you're telling the story accurately. Oftentimes people have problems remembering all of the details of what happened, but so long as you remember, for the most part, what happened, why it happened, how it happened, those are the kinds of things that you'll talk about at a deposition. But depositions are very important because when a plaintiff does well at a deposition, that gives the defendants an opportunity to assess your credibility. And if you come off to be a very credible person, oftentimes that can lead a defendant to want to settle the case sooner rather than later. And that's generally to the advantage of most people. Most people don't want to wait 18 months, 24 months before actually going to trial. A lot of people don't even want to go to trial. A lot of people don't want to sit in a courtroom. They don't want to be on a witness stand. And so one of the ways that can be avoided is to make a very good, strong showing from the very beginning of your case, because it lets the defendants know that you're a credible person. What happened to you shouldn't have happened to you, and they're responsible for it. And so it makes sense for them to actually take responsibility for the injury that you sustained. And in our system here in the United States, the way that we get people to be responsible is through money damages. And ultimately, that's what we're going after. Now, because of COVID, a lot of depositions are done via Zoom. So for instance, if you are being deposed and you're being deposed remotely or via Zoom, you're sitting at your home or you're sitting at your office in a closed environment, and you're being asked questions by the defense lawyer, for instance. And so involved in the deposition is your lawyer. I would also be present, but I'd be calling or Zooming in from another location than you. And then there would be a court reporter that is taking down everything stenographically that's being said, because a deposition is a formal proceeding, and what you say and what others say has to be taken down verbatim, and that's what a court reporter will do. So the court reporter will be involved, and then I think I mentioned there's the defense lawyer that's going to be asking you questions. And so really at a deposition, there are three people that are involved. It's the court reporter, your lawyer, and the defense lawyer. The deposition is very different than a trial. Depositions typically take place early on in the case. And again, it's an opportunity for the defendants to ask you questions under oath to make sure you're giving the most accurate and truthful testimony possible. But have no fear, you're not the only person that is going to be deposed. Me, as your lawyer, I get to depose people that have relevant information about your case. I can depose the defendant. I can depose the defendant's employer. I can depose the defendant's friends and family members. I have a lot of leeway as to who I can depose. And so it's not just you that is going through this process, but it's everybody that's involved in the process that ultimately is going to have their deposition taken. Whether you testify at trial is a very different question than will you have to testify at a deposition. Truthfully, you'll have to give deposition testimony if you want a resolution to your case, because the defendants want to make sure that what you're saying is true. They want to understand your side of the story. They want to understand your perspective of what happened. And the best way for them to do that is to have you sit before them and to answer questions under oath. People just generally tell the truth when they are answering questions under the penalty of perjury. And so you will have to give deposition testimony, because that's what a defense, that's what an insurance company or some defendant would require you to do in order for them to evaluate your case, in order for them to make an offer to resolve your case. They're going to want to have a deposition. If it's a case where you've been injured, not only will they want you to have a deposition, but they will also want you to go through what we call as a defendant's medical exam, where a doctor that is hired by them gets to evaluate you based on the injury that you're claiming in your particular lawsuit. So a defendant will require your deposition, and they will require a medical exam so that they can make sure that the injuries that you're claiming that they caused are, they'll want you to make sure that you are examined by their doctor, so their doctor can confirm that you in fact are injured and that the injury likely came from the negligence or recklessness of a particular defendant. Once you have had your deposition taken, once depositions have been taken of all of the people that have factual information about what took place, and then once you've had your medical exam and everyone knows what your current medical state is, or what your health, once your deposition has been taken, once you've been examined by a medical doctor, and once you have completed being treated by your own doctors, then we get to the point where we have experts that are going to have their depositions taken. And the experts generally, in a personal injury case, those experts are your medical doctors, the doctors that have treated you, the doctors that know you the best, the doctors that are familiar with your circumstances, the doctors that are familiar with your injury. And once those doctors have had their depositions taken, then your lawyer will take the depositions of the defendant's experts, because they're going to have a whole host of experts that are going to try to say that you're not hurt as bad as you say you're hurt, or you shouldn't have, or you didn't need to be out of work for as long as you were. And so there's going to be a back and forth where we're deposing their people, they're deposing your people. And ultimately, when we get to the point where everybody has been deposed, there is the looming trial date. And as we get closer and closer to the trial date, that's when things get a lot more busy, and there's a lot more work to be done, because the courts require a lot of documents to be filed, a lot of documents to be exchanged with the other side. There's a lot of discussions between the sides, because we still want to see whether or not this can be resolved before going to trial. Trials are very taxing. Trials are very expensive. And as your lawyer, I'm more than happy to go to trial. But if I can resolve the case before having to expend all of the monies that are necessary to put on a trial, I'm more inclined to do that, simply because that could potentially be more money that goes into your pocket, as opposed to the pockets of really, really expensive experts that have to close down their businesses to attend a trial. So that's just an incentive, is for your lawyer to be someone that is willing to talk to the other side to see whether or not the case can be resolved before an actual trial date.